Hey everyone, Brandon here from TruckSafe. The FMCSA is making some waves with the recent announcement that it will soon be considering waiver requests that could reinstate California's and Washington's state meal and rest break laws for commercial drivers. What exactly will this mean for fleets with drivers with operations in those states? That's what we're discussing in this video, so stay tuned. Do us a favor by hitting those like and subscribe buttons below if you find this type of content helpful. The trucking industry is no stranger to mandated rest breaks. For years, federal and state hours of service rules have required most commercial drivers to take a 30-minute rest break within the first 8 hours of driving. But to date, drivers and their employers haven't had to worry about state-specific meal and rest break laws that mandate more frequent breaks. That's because in 2018 and 20, the FMCSA, at the request of many in the industry, including the American Trucking Associations and the American Bus Association, ruled that California's and Washington's meal and rest break rules, as applied to regulated drivers, are preempted by 49 U.S.C. 31141, a federal statute that grants the Secretary of Transportation the authority to prohibit states from enforcing laws that interfere with the federal motor carrier safety regime. So the federal law at issue here, again 49 U.S.C. 31141, prohibits states from enforcing rules on commercial vehicle safety that the FMCSA deems to be preempted. To determine whether a state law or regulation is preempted, the FMCSA must first decide whether it, number one, has the same effect as a regulation within the federal motor carrier safety regulations, number two, is less stringent than such a regulation, or three, is additional to or more stringent than such a regulation. If the agency determines that the state law is additional to or more stringent than a federal rule, that rule may be enforced unless the agency then decides that the state law, number one, has no safety benefit, number two, is incompatible with federal regulations, or number three, would cause an unreasonable burden on interstate commerce. Now, in its 2018 and 20 preemption decisions, the FMCSA ruled that California's and Washington's meal and rest break rules are in fact rules on commercial vehicle safety that are more stringent than the federal hours of service rules and would cause an unreasonable burden on interstate commerce. As a result, those laws, as applied to commercial drivers, have been rendered preempted and unenforceable against drivers in those states. In reaching that conclusion, the FMCSA originally determined the meal and rest break rules provide no additional safety benefit, are incompatible with federal hours of service rules, and would overly burden interstate commerce. For example, it noted in that decision that California's additional requirements that breaks be of specific durations and occur within specific intervals do not provide additional safety benefits. Based on the numerous comments it received in the docket, the FMCSA concluded that the meal and rest break rules impose significant and substantial cost stemming from decreased productivity and administrative burden. The FMCSA's preemption decisions have been the subject of subsequent litigation in numerous courts, but have been upheld to this point. So what exactly may be changing? Well, in its most recent notice, the FMCSA is actively soliciting waiver requests from those earlier preemption decisions, meaning it is inviting anyone, including the states of California and Washington, to file a petition with the agency to effectively reinstate those states' meal and rest break rules for commercial drivers. In other words, if FMCSA were to receive and grant such waivers, then the California and or Washington would presumably be permitted to once again enforce their meal and rest break rules against employers of commercial drivers. The agency explains in its notice that a petition for such a waiver must demonstrate to the agency's satisfaction that a waiver from federal preemption is in the public interest and consistent with the safe operation of commercial motor vehicles. The FMCSA is further requesting that any such waiver petitions address the following three questions. Number one, whether and to what extent enforcement of a state's meal and rest break laws with respect to intrastate property carrying and passenger carrying commercial vehicles has impacted the health and safety of drivers. Number two, whether enforcement of a state meal and rest break law as applied to interstate property carrying or passenger carrying commercial vehicle drivers will exacerbate the existing truck parking shortages and result in more trucks parking on the side of the road, and whether any such effect will burden interstate commerce or create additional dangers to drivers and the public, and whether the applicant intends to take any actions to mitigate or address any such effect. And number three, whether enforcement of a state's meal and rest break laws again, as applied to interstate property carrying or passenger carrying commercial vehicle drivers, will dissuade carriers from operating in those states, whether any such effect will weaken the resiliency of the national supply chain, and whether the applicant intends to take any actions to mitigate or address any such effects. So what will be the impact of these waivers if they are ultimately granted? Well, to answer that, we have to take a look at California's and Washington's underlying meal and rest break rules. Generally speaking, those rules mandate that employers provide employees working in their states a 30-minute meal break for every 5 hours they work, and an additional 10-minute rest break for every 4 hours that they work. Practically, this means motor carriers with drivers in those states would potentially have to allow 3 times the number of breaks that they do under the current hours of service rules. This would in turn have some pretty significant consequences, as you would expect, which the agency already addressed in its earlier preemption decisions, including an exacerbation of the existing truck parking shortage. If drivers are going to have to take 3 times the amount of rest breaks that they do currently, then it necessarily follows that the truck stops and other resting locations could see a significant increase in traffic. In sum, the underlying motivations of the FMCSA's recent notice aren't clear, but given that the agency is actively soliciting waiver requests, we have to assume it fully intends to grant them. Ultimately, we expect California and Washington will file these types of requests and that the FMCSA will grant them. If that happens, then motor carriers with drivers in these states will likely have to comply with these additional meal and rest break requirements. And the burden on interstate commerce that the FMCSA itself acknowledged in 2018 and 20 could become a reality. That's going to wrap things up for this video. For even more in-depth information about these types of regulatory topics, be sure to check out our innovative online compliance courses for safety managers and for drivers over at trucksafeacademy.com. Also, be sure to check out our detailed compliance articles on our website at trucksafe.com and follow us on our various social media pages for the latest highway transportation news and analysis. Thanks for watching.